Trump said, "You gotta resign, buddy," and he refused. So Sondland was fired by Trump in 2020.
You said it was a no for me after that, January 6th.
I did.
And here we are right now.
I did.
And you're saying it's a yes for you.
It is a yes for me. It is an absolute yes for me. That is how badly the Biden-Harris team have prosecuted their job.
Jack moved to quadruple its applicable page limits. Can I have a bunch more space? Because I'm going to just dump everything we have. An impeachment witness has now reversed course. He's back on the Trump train, baby. This guy, Gordon Sondland, is an American businessman, was at one point a United States ambassador under the Trump administration, but then he testified at the Trump impeachment trial #1, which was fake. Trump said, "You gotta resign, buddy," and he refused. So Sondland was fired by Trump in 2020. Wow. So he must hate Trump, right? Must never want to vote for him again because of the danger to democracy and blah, blah, blah. Wrong. He was invited onto this show called MSNBC's The Beat, not to be confused with Doug Emhoff. It's another host. But this is what he said on the show.
A no for you after that. Why was it important for you to say no more Trump because of his January 6th conduct? And do you stand by that?
No, I don't stand by it, and I'll tell you why. I've now lived 4 years under the Biden-Harris policies, and I have to say that those policies are not only becoming an existential threat to our country's way of life, but to our allies as well.
So when you
and
Ambassador, this is I'll let you finish, but this is so striking. You said it was a no for me after that, January 6th.
I did.
And here we are right now.
I did.
And you're saying it's a yes for you.
It is a yes for me. It is an absolute yes for me. That is how badly the Biden-Harris team have prosecuted their job.
But the whole point you seem to be making was that January 6th and that kind of attack on democracy is bigger than any policy difference.
I am seeing so many attacks on democracy that eclipse January 6th.
So I want to ask Sarah,
if you want to ask me what those are, I'm happy.
It's true. Guy's right. Guy's true. He's like, shoot, man. Look, I testified against Trump, and now I have to vote for the guy because Kamala and Biden have wrecked everything. They're wrecking free speech. They're prosecuting their political opponents. They're trying to take their political opponents off the ballot. Borders wide open. We're being invaded by foreigners. I mean, the whole thing's a disaster. So a great clip. Welcome aboard. So let's go back through what's happening in the January 6th case. From Judge Chutkan's courtroom, Donald Trump is responding to special counsel, so-called illegal prosecutor Jack Smith's 165-page so-called opening brief that was boring and repetitive, and that's feeling like it's largely being forgotten by the media. They're talking about it a little bit, but there's no big salivating in there, really, because we've already been beating that horse to death thanks to Liz Cheney for the last 3.5 years. But here is what Trump's defense team said in response. They said, all right, listen, Judge, you gave Jack Smith 165 pages. Now, guess what? We want 180 pages back. We also want a 5-week extension. So this is curious, isn't this? Watch. Of the deadline to file his response, Trump's, and additional leave for a surreply. So the kind of the final word, we'll think of that as, because we're going to see they combine some motions and there's different filings. And so Trump will ultimately, it looks like, have the final word on these issues by December 19th is what he's requesting. Now, the special counsel returned a superseding indictment. Here's the background. On August 27th, this is Jack Smith's second attempt. Now, thereafter, the parties filed a joint status report. Now, in the submission, Jack requested leave to file an opening brief, which we read. Now, that it claimed would justify its own charging instrument to explain why the immunity in the Supreme Court case doesn't apply to Trump in this new indictment. Now, Trump objected to this because it violates criminal procedure. No one's ever seen an opening brief of 165 pages and unconstitutionally deprives him of his Sixth Amendment rights to confront his accusers, to call and cross-examine witnesses, the Confrontation Clause. Now, instead, Trump requested a standard briefing sequence, which would have been ordinary, which would have entailed President Trump to raise issues, and the court could have resolved several threshold questions of law before even entertaining all of this other stuff. We didn't need to see Jack Smith's 165 pages if this case would have been dismissed because we answered this question. Like, do we need to do all that work? If we just answer this, then we're going to be done. Now, the court held a hearing on September 5th at the hearing, which Chutkan had postponed for 3 weeks at Jack's request. Jack disclosed that its proposed immunity briefing was already underway. Wait, Jack was already working on it? What? But that it required an additional 3 weeks to finish drafting so it could package all of its exhibits, right? Now, despite this prior work, the special counsel, Jack, did not indicate that its proposed brief would exceed the district's page limits at that time, right? So back at this date, Jack's like, yeah, we'll just follow the normal submission rules, standard page lengths, and more. But over President Trump's objection, they said, no, you can't submit an opening brief. This is totally outside of the ordinary. What kind of ridiculousness is this? The court granted the request anyways. And moreover, the court also granted Jack's request for an additional 3 weeks so he could finish his drafting. They set a deadline late September. Now, the court did not alter the applicable page limits at that time either. And based on those standard limits, they ordered Trump to respond by the 17th. Then Jack would respond by late October. The court also indicated that although this schedule would allow Jack to file 2 briefs instead of the 1, that it wasn't unfair, because if Trump wants to file a surreply, right, if Trump wants to have the last word, he can ask for leave to have the surreply. So it's just a matter of who goes first. It doesn't really matter, but we'll give you the last word. So finally, the court ordered that Trump submit replies and supplement his statutory motion, which we'll read, and file a motion to leave to dismiss the appointments and the appropriations clauses by these dates. So Trump continues, he says. So then, on September 21st, less than a week before Jack's big immunity brief was due that we read yesterday, Jack moved to quadruple its applicable page limits. Can I have a bunch more space? Because I'm going to just dump everything we have. Jack notified Trump that he would seek this relief just 1 day before he sent it into the judge. Trump objected. He said, Your Honor, objection. This is unprecedented. The unprecedented and irregular nature of the office's approach on remand is ridiculous. But the court overruled President Trump's objection, holding that the length and the breadth of the government's brief was appropriate because it was uniquely challenging to address immunity issues when you're prosecuting political opponents. My words. Then on September 26th, Jack filed its oversized brief, together with an extensive appendix and hundreds of exhibits all under seal, which we read the brief, but the exhibits and the referenced items are still under seal. Jack further moved to seal an unredacted copy of its brief while proposing redactions for the public filing, and the court ordered that Trump respond to those things, and so they did. Now they say, Your Honor, Judge Chutkan, in the January 6th case, this court should grant Trump 180 pages to match what you gave Jack. He had 165 pages plus another 15 for the other motion. The court has decided over Trump's objections that extensive factual submissions are appropriate now. And so if you've decided that, which we disagree with, Trump must have an equal opportunity to address and submit this and to rebut Jack's misleading submissions. So Trump should have 180 pages. And in addition to that, Your Honor, Trump also wants a 5-week extension of this filing deadline. This resembles the 3-week extension that you gave to Jack Smith back in August. In total, the requested extension would give Trump 8 weeks to file his response, which approximates the 6 weeks that you gave him. Here's why we need it. The enormous size of Jack's filing is going to take substantial time to review. The important issues at stake, like the underlying immunity question, it raises multiple unprecedented, momentous questions about the powers of the president. So, as Chutkan indicated previously, Judge, Trump should have the same time and sufficient time to respond. You even said, Your Honor, you can have time to respond during the hearing. You can have additional time during those 3 weeks. Now here, given the extraordinary and only recently disclosed quadrupling of the submission length, we need 5 weeks. No one's going to be prejudiced by this. At the same time, Trump will continue his work on other pending motions. We have a bunch of stuff that's due in the near future, and this is an enormous undertaking to review these hundreds of exhibits. So to do that by the 17th is not practical. It's at odds with what the Supreme Court said we need to do here, so we need to postpone this until after the election. Now finally, Trump also does want to file the final word, the surreply. As noted above, both President Trump's opposition says under ordinary circumstances, Trump would have every right to file a reply in support of his motion. And so it's not just about going first. Additionally, a surreply would not provide Trump any unfair advantage, and the judge is going to grant him that. So the court should grant President Trump the right to file a 180-page response, including a surreply. It looks like Jack doesn't object to a 180-page limit, but does oppose the deadline extension and for a surreply. All right, so Jack is objecting to 2 things there.